Hi, I'm Shannon Gunn Emery, a lawyer with Gunn Law Group. And today on Legal Eyes, we're going to be talking about spousal support. Spousal support, a term that strikes fear in the hearts of some, and perhaps hope in the hearts of others. But in the eyes of lawyers, it is a lovely, messy subject. There is nothing clean and clear about spousal support. And of course, I have to warn you, this is not legal advice. You cannot take this to the bank. You cannot use it to strong-arm your spouse. What you can do with it, and hopefully what you will be able to do with it at the end of this podcast, is to understand where a court would be coming from and to keep in mind what you have to think about if you're in the situation where you might be the payor or you might be a recipient. Let's explore. The first question to figure out always is there entitlement? If there is no entitlement, we don't have to go through quantum, duration, all that kind of thing. We just don't go there at all. Now, as a lawyer who spent a lot of time in criminal law, I was constantly looking for the test. I like tests, legal tests. Was there any evidence upon which a jury, reasonably instructed, could have convicted? Do those skimpy or confusing reasons by the trial judge allow for meaningful appellate review? I like tests, and I get very few in family law. Instead, what we get are lists of things we have to consider, things we should keep in mind. Like I said, a lovely, messy subject. So, the first step is trying to figure out, is there entitlement? Is there a reason why someone is entitled to spousal support? It is a threshold question. What do we have to think about when we're trying to figure out entitlement? And to make things a little muddier, in order to determine spousal support, we also have to figure out what is the basis upon which we're seeking spousal support. Is it contractual, compensatory, or non-compensatory? Are you thinking right now, Shannon should be happy, this is sounding a lot like a test? Well, kind of. Let's put our legal eyes on and take a closer look. Contractual, yes, you guessed it. It's on the basis of a contract, a prenuptial agreement. I'm sure you've heard of them. In movies or in the papers, some rich person decides to get involved with someone who has practically nothing, but forces them to sign a prenup. If they really did force them, it likely wouldn't be enforceable. But anyway, a prenup may form the basis of a claim for spousal support under the contractual category. I believe that a cohabitation agreement could also come under this category. Frankly, even if you didn't call it much of anything, but it was in writing, it was witnessed, it was signed, especially if it was the product of independent legal advice, you may have a basis for arguing for contractual support. Or you may have a powerful tool to argue against it. Compensatory support also gives a clue in its title as to what it's about. Yes, you are right. It compensates a spouse for sacrifices they might have made during the relationship that allowed the other person to benefit and to be in perhaps a stronger position exiting the relationship than the sacrificing spouse. Non-compensatory, though, went a little further in Bracklow and Bracklow, a case from the Supreme Court of Canada that really changed things. They said, yes, there could be situations where someone has given up something, but we can also look at this a little differently. What if leaving the relationship, one person just definitely has more money, is in a much better financial situation, and the other one is in a precarious situation, and not one at all that they were used to when they were together? We need to look at the means and the needs of the couple. Does one party have the means to pay more to the other spouse? and is the other spouse in need of it? In a case called Killips and Killips from 2018, the Alberta Court of Appeal was faced with a husband who pointed an accusatory finger at his spouse saying, "But she's self-supporting. She doesn't need spousal support." The Court of Appeal said this: "We see no basis for this court to interfere with the trial judge's finding that the respondent was entitled to spousal support. Entitlement to spousal support is not solely a matter of need, but one factor to consider," and they cited Bracklow and Bracklow. The court then looked at the wording in the Divorce Act. In deciding whether or not to order spousal support, the trial judge must consider the condition, means, needs, and other circumstances of each spouse, which includes considering the length of the marriage, the functions performed by each spouse during the marriage, and any agreement or arrangement the spouses made regarding support. In Killips and Killips, the Court of Appeal decided that the trial judge looked at the condition, means, needs, and other circumstances of each spouse, and he was right in ordering spousal support. In another case called Rockall and Rockall, Mrs. Rockall had AIDS, and Mr. Rockall was aware that she was HIV positive when they began their relationship, and certainly was aware before they got married. It's an interesting scenario because when Mrs. Rockall moved into Mr. Rockall's mobile home, she didn't have a lot of goods at that point, and when she left, she didn't have many either. The court did not find a contractual basis, nor even a compensatory basis for spousal support, but they said that her ill health did entitle her to non-compensatory spousal support. AIDS had removed from her the ability to support herself and to replace the benefits she had experienced while cohabiting with Mr. Rockall. The court made another comment, which comes up often in these cases, which is support should not be confined to a subsistence lifestyle. Support should be based on a consideration of the lifestyle enjoyed by the parties while living together, and they cited another case called Riyadh and Riyadh from 2002. Now, before any potential recipients of spousal support get all excited about thinking that they are going to live the lifestyle that they were used to, no, that is just one consideration that the court will think about, but you have to be realistic. When you have one household and now you've divided it into two, it is very unlikely that either of the people in these new households are going to live the lifestyle that they used to. It just isn't mathematically really feasible. And if someone goes asking for that, well, they're going to be disappointed. So, if after looking at any contracts, the length of the marriage, the roles each played, any sacrifices someone made, their respective conditions, means, and needs, if after looking at all that, there is a determination, yes, someone in this relationship is entitled to spousal support and someone has to pay, well, then what do? Well, the next step would be to determine income. And that is not always easy. I am sure you will find this very difficult to believe, but sometimes people try to hide assets, or they try to make it look like they don't have as much as they actually do. No, it's really true. It happens. So the courts have had to deal with imputing income. That means where someone is deliberately, or maybe not deliberately, underemployed or unemployed in order to avoid, or maybe not to avoid, spousal support or child support obligations, the court can say, no, you could have made this much, and we're going to assume for the purposes of support that you actually did make that much. Now, why was I so cagey with my language? Because the test in Alberta, yes, a test, a real test, but don't get excited yet. Very recently, on Halloween 2022, changed. The Alberta Court of Appeal came out with a decision called Peters and Atchue. No, I did not sneeze. That's the name of the case, Peters and Atchue. 2022 Alberta Court of Appeal case, and it was a humdinger. Why, you ask? Because It overturned a previous decision, commonly referred to as Spousal, which had been decided 21 years earlier, and which had put Alberta out of step with every other province in the country. We do like to do things differently in Alberta, but the Court of Appeal in Peters and Atchue decided this time it was the rest of the country that actually got it right. In Spousal, the majority of the Court of Appeal had decided it was only when someone was intentionally underemployed that one could impute income. The majority judgment held that one could only impute income where there was proof the payor had pursued a deliberate course of conduct for the purpose of evading, in that case, child support obligations. Income could not be imputed unless there was proof of a specific intention to undermine or avoid child support obligations, or if the circumstances permitted the court to infer that that was the payor's intention. So we really needed bad faith or deliberate evasion in order to impute income. 21 years later, Justice Picard's original dissent in Spousal governs. She must be happy about that. It took them long enough, but the rest of the Court of Appeal finally agrees with her. If she is not at this moment jumping up and down, saying, "I told you so, I told you so," well, she ought to be. Madam Justice Picard had held, given the fundamental responsibility of parents to support children, it is enough to prove that the payor has capacity to earn more than he or she does, but does not do so based on a choice that is unreasonable in the circumstances. The reasonableness test was what the rest of Canada was using for the past 20 years, and it is now what we have in Alberta. Imputing of income can go both ways. One can make an argument that the recipient of spousal support is not doing enough to become self-supporting. Relatively rare, but it can happen. In spousal support, we sometimes say that there are always two salaries involved, even when one person isn't working. Once you got through the threshold question of entitlement and you're starting to look at income, you can see how it could become somewhat difficult. And it becomes even more difficult if you have a farm involved, or you have a self-employed person, or there are corporations involved where assets are being shifted continually. So determining income can be tricky. But once you've got that down, then you're going to start turning your eyes towards the Spousal Support Advisory Guidelines, otherwise affectionately known as the SAGs. What a horrible acronym, honestly. Couldn't they have thought up something else like Spousal Awards Suggestions, SAS? That would sound so much nicer than SAGs for the Spousal Support Advisory Guidelines. Someone needed to give that a little more thought. Anyway, that's where we go. Now, you may have heard of the Federal Child Support Guidelines. Those, although they have guidelines in the name of it, they're really treated like law. If you decide to depart from the Federal Child Support Guidelines, you're likely going to encounter a resounding no from the courts. If you're willing to pay more for child support, it probably won't be a problem. But if you're trying to pay less, good luck. The Spousal Support Advisory Guidelines, on the other hand, are really treated like guidelines. They are a starting point for a discussion. Now, when I first started looking into spousal support, I turned my legal eyes to the Spousal Support Advisory Guidelines Revised User Guide, affectionately known as RUG. You think I'm making it up, but no. The RUG, no, I can't. The user guide was very helpful and outlines a number of principles that I think you might find quite interesting. Here's a little tidbit. Income disparity alone does not mean there is entitlement. Another one is that entitlement is not only a threshold issue, but an ongoing issue, as after a spousal support order is made, often there are reviews or variations, and it may be that during a review or a variation, one may find upon looking closely that entitlement is no longer there, even when there is still a continuing income disparity. Some factors to consider: ability to pay, or high debt payments, mortgage payments, or that the recipient is living in a mortgage-free home. All of these are valid considerations. Another little nugget from the guidelines: while the threshold to vary child support is quite low, the threshold to vary spousal support is significantly higher. Another one: it is not any long marriage that gives rise to compensatory support. We really have to look to see if the economic loss or disadvantage experienced by the one spouse is as a result of roles adopted during the relationship, or the potential recipient's conferral of benefits to the other without adequate compensation. I could go on for a while. I'm going to leave it at that because I'd like to look at how we actually use the Spousal Support Advisory Guidelines to come up with the number. And now we come to the part of the podcast that may sound a little like product placement, but that's not it. There are 2 software programs, primarily, there may be others out there, that lawyers use to calculate spousal support. There are probably other ways of doing it, but they might be difficult. There is ChildView and there is DivorceMate. Our office has used both, and so I can say that both are very good products and will do the job. You start by putting each party's name into the program, their respective incomes, when they got together, when they ceased to be together, their respective ages. You click a button like calculate, and voila! You get 3 sets of numbers: low, mid, high, within this range of spousal support. Now, going back for a moment to the user guide for the Spousal Support Advisory Guidelines, one thing they did mention a couple of times is that the mid-range is not the default position. Also, a 0 in the low range or even in the mid-range does not necessarily mean that there is no entitlement to spousal support. It may mean that actually there's no ability to pay. The numbers produced by these programs really serve as a starting point for discussion. We can look at them and we can say, okay, these are the numbers that we could be working with. What would put us at the higher range? What might put us at the lower range? And look at also, again, the conditions, means, needs, and other circumstances of this couple. It's fine to say that somebody is entitled to $1,500 a month, but if there's only $300 in the budget, we've got a disconnect. It doesn't mean we only pay out $300, but we might have to become creative in how we figure out an alternative. I've had it happen more than once that the payor had already been making payments, knowing that payments were going to have to be made, and had been paying too much. And then when looking at the numbers generated by counsel using either ChildView or DivorceMate, appeared to be rather shocked, and the other party appeared to be quite concerned. And yet, there could be good reasons for going to the higher range on spousal support. Similarly, there may be reasons why even the lowest range doesn't work. As I said, this is a starting point for discussion. That discussion also needs to include issues concerning whether spousal support is going to be paid as a lump sum or as periodic payments. The differences between lump sum support and periodic support can be quite significant. Couples need to give it a lot of thought. Here are a few considerations to keep in mind. Each option, for example, has different tax consequences. If you pay it as a lump sum, it is neither tax-deductible for the person paying, nor is it taxable in the hands of the person receiving it. If, however, there is monthly support, there is a tax reduction for the person paying, and there will be tax owing for the person who is receiving it. So one has to be careful when making a decision as to whether or not to offer or accept lump sum support. Doesn't mean you can't, but you do have to account for the difference in tax. But there are other factors to consider when choosing between lump sum or periodic spousal support. With lump sum support, one can invest that money. We know it's certain. You have it in advance, and so even if ill health strikes later, that money has been already paid, and you don't often get take-backsies in spousal support. And therefore there is value to that. The person receiving it at that point has maximum flexibility with respect to what to do with it. On the other hand, periodic spousal support provides a sense of security for some people. Some people just want a monthly amount. They want to know that that income is coming in every month. Even if they could invest it themselves and dole it out to themselves on a monthly basis, it doesn't feel the same. Another factor to consider, of course, with respect to lump sum versus periodic, is whether or not the payor can actually pay lump sum spousal support. I mean, after all, where are you going to get it from? If you had to divide property already, so now you're down to half of what you used to have, your finances may be a little strained. And so trying to find a lump sum payment to pay out the other spouse can sometimes be difficult and make it either not a great option or not an option at all. When it comes down to periodic spousal support, there will be a number of factors to consider other than just the low, mid, and high range that the support program has suggested. If the couple opts for periodic support, there's another big question that comes up. For how long will spousal support be payable? No doubt about it, the question of duration can cause a lot of stress on both sides. Roughly speaking, the spousal support guidelines say that support should continue for between half and 1 year for each year that the parties lived together. But when you use child view or divorce mate and the low, mid, high range come up, it will also give you an idea of duration. And sometimes the duration is indefinite. Now, the guidelines user guide specifies that indefinite does not mean forever. It means we just don't want to put a clean, clear number on it. We have to do reviews. We have to evaluate it. It's going to be a little tricky. However, from a practical point of view, although it may not mean forever, indefinite clearly means it is not going to be a short amount of time. No, in that case, in the spectrum of duration, we're definitely on the longer side. A few more factors to consider when trying to come up with the sweet spot for spousal support. If there was, for example, an unequal division of marital property, favoring one spouse over the other, that may be taken into account when it comes into where we should be situating ourselves in that low, mid, or high range. Another example, one may take into account the types of property that were transferred. In particular, pensions. If someone has a huge pension and the couple has decided to split it, well then the person who would be receiving spousal support may not really need it as much given that extra income. Another factor, what if both sides, both parties, had a kind of claim to spousal support? This can happen. You can have one person who made sacrifices to help the other advance their career, but then later, once that career took off, that spouse who benefited ends up helping the other spouse who initially made sacrifices. Those kinds of factors can influence whether we are on the low, mid, or high range of the spousal support spectrum. Another issue to consider: what happens if you have the type of income that is really variable? It's seasonal, or it's dependent on factors which are sometimes a little beyond the worker's control. So you could have a great year, or you could be stuck with a pandemic and have a lousy year. When looking at spousal support as well, we're looking at what is the net disposable income for each party. So what do they have in their pockets at the end of the day? Because we don't want to make such a huge award for spousal support that the payor is left destitute, whereas the other person doesn't have to work at all and just takes it all in. That's a horrible situation. On the other hand, you don't want the spousal support award to be so little that one person is living the life of Riley and the other definitely is not. So we are always looking at the conditions, means, needs, and other circumstances of each spouse. And that's what helps us to determine where in the range we should fall. Now, once spousal support has been decided and there's a written agreement, everyone feels, we got to the end, we made it, we're done. Well, you can have reviews. And reviews happen because circumstances change. A spouse may repartner. One person may retire. Another may end up getting a different job or winning the lottery or being struck down by lightning or being incapacitated. And lawyers try to imagine all the scenarios that could happen. We have a laundry list. Ultimately, what we try to do as lawyers is draft an agreement that says very, very clearly, this is what the couple wants, and please, Mr. Justice, Madam Justice, stay out of it. But they might not. So we have to be flexible. And last but not least, at least for this podcast, there are waivers of spousal support. Unlike child support, you can waive spousal support. That means that it may be owing, maybe everybody agrees that it's owing, but there are reasons why one person does not want spousal support. And I have seen that more than once. Frankly, even when we determine that spousal support is probably not owing, in our written agreement, we normally do a waiver of spousal support to make it clear that no one is to come back years later claiming spousal support. I have also seen it where each party had a claim to the other, potentially, for spousal support, and just to make things clean, decided mutual waivers of spousal support was the way to go. Normally, when there is a waiver of spousal support, it is on both sides. Often, the potential payor cannot imagine actually having recourse to their spouse to supplement an income that has somehow disappeared, but you never know, it could happen. Waivers need to be clear and informed. It is very important to get good legal advice before you sign or agree to any waiver of spousal support to which you might have been entitled. And on that happy note, we are going to wrap it up for today. Suffice to say, there is a lot more that we could talk about concerning spousal support. But I think you've got a glimpse of what it's about, the main issues that we normally talk about, and probably an understanding of its complexity. It's complex because we as people are complex. Our relationships have so many layers to them. Please follow us again next time when we talk about how to argue and hopefully win a Safe Roads application. All our tips and tricks. Talk to you soon.